Hi, this is Dr. Clare Steffen, and I'm here today to talk with you about custody. And we have Judge Timothy Murphy from Chicago with us. So, Tim, you were starting to tell me a little bit about the fact that we no longer use the term custody in some states. Can you tell us a little bit about that?
Sure, and good morning to you, Claire.
Good morning.
Illinois' legislature adopted several new acts wherein the nomenclature changed substantially, although much of the law remains the same relative to what used to be known as custody and visitation. In Illinois and certain other states, it's now called allocation of parental decision-making.
Wow.
Allocation of parenting time.
Okay. Yeah, that's quite a mouthful.
Yes, it is.
Yeah.
The
So,
substance is the same, but the nomenclature differs now.
Changed, yeah. And I was going to ask you about the different types of courts or divisions within the court as we get started too.
Okay. Well, Cook County, Illinois is approximately 7.5 million people, and it's one of the largest legal systems in the country. And something that's probably unique or somewhat unique to Cook County, Illinois is that we have specialized divisions in the court system due to the number of people that utilize the court. So for instance, I sit in the domestic relations division. We have a division for criminal law. We have a division for child abuse and juvenile proceedings, and then multiple other divisions such as the criminal division and so on.
And do they sometimes overlap in a case that you might be handling?
They do, particularly when it comes to children and the parental authorities. So
Okay.
for instance, there may be juvenile proceedings for abuse and neglect, and the parents or one of the parents might be petitioning in the domestic relations court. So let's take a parentage situation, i.e. the parents are not married, and the police get called and they remove a child for allegations of abuse against a mother, and then father would get notified of those proceedings. They would be in the juvenile court because it concerns abuse or neglect, but the father then might file a petition for custody. We'll use that phrase in our conversation today.
Yeah.
In the domestic relations division. In an instance like that, we here in Illinois, we generally let the courts that are specialized deal with that part of their case. But frequently what we'll do is we'll get on the phone with the judge in the other division and make sure that we're not duplicating proceedings and efforts, and also make sure that we stay apprised of whatever types of orders have been entered.
Okay, and so this slide here that shows your standing orders, is this just an explanation of some of the types of duties you have as a judge, or what is this that we're looking at?
Yeah, that's correct. It's primarily for the attorneys and the litigants so that they know the daily schedule. However, some of the things, for instance, number 3 up there, focus on children. That's a parenting class. And in my standing order, it indicates that parents are required to take that class. Some of these are procedural and some are kind of directives to the attorneys and the litigants.
And when you say directives, you mean things that they must follow or must do, or?
Correct.
Yeah. Okay, I'm going to move along then. And so, this is something I think the students will find interesting. You know, it isn't always easy to blend the different professions. And I've been thinking about this in respect to coming from psychology or a mental health perspective. Sometimes we have a tendency to want to think that maybe the individual in front of the court is perhaps not responsible for their act because of a mental illness or because of a substance use problem. But then when I think about that from, you know, a fuller perspective, in some ways we may be preventing them from getting the type of service that they really need. And in the case when there might be victims involved in their actions, then it's an injustice to those victims. And in particular, if it's children, we have a duty to protect. You know, and so I don't know if you've had some experiences with perhaps the tension that can be in those differences between evaluators who are psychologists and dealing with the legal system. Or seen anything that might be difficult that way?
We do see some of that. The overriding concern in domestic relations proceedings and juvenile proceedings is the best interest of the children.
Right.
So while it may be true that a parent needs certain treatment or whatever, we are more concerned about the welfare and the protection of the children. So I think our focus may be different. Even DCFS, which is our
Child Protective Services, yeah.
Right. They have, sometimes they have a different standard in terms of when they act than when the court may act.
Right.
So working in the field, and I'm sure it's the same with you, we kind of learn those nuances, and it's not that we're necessarily in conflict with the other entity. It's that our focus may be on a certain outcome as opposed to what their focus is.
Yeah, and that says it well. And it is a matter of, you know, being able to understand the differences, like it says here in language, or, you know, some of the other issues that may come up in regards to expectations of how things are going to come out. And I think the more you work with a particular evaluator, the more that evaluator gets to understand the expectations in the court and vice versa.
I agree.
In some of the places that I've, you know, worked as an evaluator, we offer mediation services within the system, and I know that's true in Chicago. And our approach has always been to try to mediate things out first. And if that isn't possible, then it would escalate and require an evaluation. Is that the same kind of process that you have there in Chicago?
Yes, we have, fortunately, being in such a large population and court system, we have some ancillary services that are available to our litigants. As I mentioned earlier, the Focus on Children program for all parents going through either a divorce or a parentage case. It's actually mandated statewide. That's administered by one of the branches of the court. It's our Marriage and Family Counseling Service. They also do mediation for parents, primarily on the allocation of the parenting responsibilities and parenting time. There are private mediators that are available, and some families utilize those. There are other services depending on the nuances of the case that might be available, again, through some of the ancillary services court system. We have an office of the public guardian, which are attorneys that we can appoint to represent the children's interests. And that also is more unique to Cook County than some of the other counties in our state because of funding issues.
Right. And we don't see that quite as often out here. And I didn't see it so often when I was doing this work in California either. And I think it is, like you say, budgetary, that sometimes the communities don't have those kind of funds available. And so then it would fall in that case on the family to hire the attorney themselves to represent the child. So,
Yeah, the courts can appoint private attorneys for that purpose as well, and that's what they do in other counties. Generally, those attorneys have to have a certain level of experience and
yes.
training before the court will consider their appointment.
Sounds good. All righty. So now we're going to get down to, the bare bones of child custody evaluation. As you've already pointed out, they can be either court appointed or done privately. The focus is on the best interest of the child. And maybe you could talk a little bit about some of the different terminology, and maybe this has changed in your courts too, but about legal custody versus physical versus joint versus sole.
Sure. Well, let's start with physical, because it's a phrase or a term that we don't use too often. It tends to be used on a very temporary basis. In fact, in parentage cases more frequently than others, we may see a non-parent coming into court and petitioning for what we'll call custody, and they have physical possession of a child. It may be a cousin or some other individual that the child's been living with, sometimes placed voluntarily, sometimes under other circumstances. So another instance where we might grant just physical care is where one parent has had custody and the other comes in now alleging that the child is living with him or her, and maybe alleging some type of emergency exists. So these tend to be temporary orders until we can get enough information to address the more permanent situation.
Okay.
So physical custody is used infrequently. Joint custody and sole custody are generally more permanent awards to one or both parents, obviously, if it's joint custody. In Illinois, if we grant joint custody, we have to find that the parents have the ability to communicate and cooperate and make decisions together regarding the children. And if we grant sole custody, it's generally after a finding that they cannot do that, and that it's in the best interest of the child that only one parent have that authority. Certainly joint custody is the preferred outcome, and I believe most parents are able to co-parent, but in some instances they're not able to cooperate. And it may only be in limited areas. They might be able to cooperate on certain decisions, but not in others. For instance, religion can be a sticking point where we might have to determine whether it's best just to allow one parent to make that decision. Sometimes education, sometimes other areas.
And so what that's going to look like, I suppose, would be mitigated out through the parenting plan. So you can have joint custody, but it could have different plans. So it could be 50-50 or 20-80, or it might look like different things depending on the family. Is that right?
Yeah, it may be a hybrid of joint and sole. Of course, we want parents to come to their own parenting agreements wherever possible. But in any event, it's best to tailor the agreement to the particular family and their strengths and abilities.
And needs. Yeah, and as an evaluator, oftentimes I would come to that determination about a plan and what it might look like after conducting several interviews with the parents and the children, and interviewing teachers, and in cases where there was domestic violence, looking at police reports and many different other resources. Some of the cases I did would involve psychological testing, and those in the courts I worked in tended to be more private cases than the court-appointed cases, which didn't afford the time or budget to do psychological testing. And so it was really on me to do, more of the collateral work in order to get as much information as possible to come up with the best plan for that family.
Yeah, we're fortunate here in Cook County, Illinois. We can also order home studies, which is, again, through one of our ancillary services, where they will go out to the respective homes, interview the parent and the child there. They will run the criminal background to see if there's any. As in many things, funding is a big concern. It's particularly difficult if there are not services available through the through the state or county, and people have limited means to afford to have any of this stuff done separately.
Yeah, and that was most of the cases I was working with, was people who didn't have the funds, and so they relied on the court to provide that service. And these were generally high conflict cases where they couldn't resolve them through any means of mediation. They had tried several times, and so they'd be bumped up to meet with an evaluator such as myself. And, these are just some of the factors we would have to consider. And one of the things we did have, as you mentioned, was access to finding out about criminal records. And so we would run what was called a CLETS, and that gave us access to any history of, arrests or any other kind of legal problems that might be in their background. And so some of the, folks I might interview along with the parents would be step parents, and looking at the sibling relationships, and when possible, step and half sibling relationships. We didn't have the capability to go out and do home studies, and so we didn't really have that information available to us. And so that's where, again, doing, really extensive interviews and relying on the criminal records was important.
Yeah, well, of course, it's very important that if somebody's doing an evaluation, that they have the opportunity to interview other collaterals, particularly people that may be living in a household that the child either lives in or spends a substantial amount of time in.
Yeah.
I like to explain to the lawyers that when they're coming for trial before the court, they should be painting a picture, and we want the whole picture. I would say the same would be true of an evaluation, that the more information that is available to the court about everything affecting the child, the more it's going to help the court.
True. And, most of the time these reports were very extensive. So on the short end, it might be 25 pages, but, typically it could go up to like 60 pages of information gathered on these families. And, I would get the opportunity to talk to Child Protective Services, or out here it's called Department of Human Services, to see if there was any cases pending or any history from the past on this family. And if there were mental health providers, that one gets a little slippery at times in terms of what you can report in terms of mental health background and issues.
Right.
And we tended not to label diagnostically in our reports unless it was an issue of safety or harm to the child, that a parent had a mental health condition. Substance use history has gotten interesting because of the changes in the language on how we define substance use problems. They no longer look at history of DUI as a way to determine whether or not someone has that condition. And so that's a little different than what you might see, I suppose, in the legal system, where you might be more interested in wanting to know that history.
Right. Yeah. Under the best interest standard, we can consider pretty much anything that is relevant to that inquiry. Of course, certain things are excluded under HIPAA and other laws. But even under those laws, there are exceptions that might allow the court to have that evidence introduced into court. I think that's an important thing for evaluators to be aware of.
Right.
Another issue is the age at which children can seek that HIPAA protection. I think it's 12 or 13 years of age.
Mm-hmm.
And that can be problematic. So if the child doesn't have an attorney in the proceedings before the court, sometimes things are not brought to our attention.
Yeah, and the other thing we moved in the direction of, when a child reached the age of 14, they had more say in the decision making as to which home they wanted to live in. And so they had more of a voice at that point in time as to what they felt was in their best interest. And that's where you'd see some of the background on their activities they were involved with or outside interests. And maybe some of these issues around LGBTQ could come up as the child's developing, if there's one parent who's more understanding or accepting or aware, or if there's any issues of substance use in the child, that could be another issue. And I should say, I don't ignore DUI history. It's just we no longer use it to determine whether or not somebody has a diagnosis. Doesn't mean we are not still interested in that information.
Okay. Let me comment on a child's preferences in terms of custody and living arrangements. In Illinois, it is a factor that the court can consider. There's no bright line age. What we look at is the maturity of the child, their ability to articulate their concerns or preferences, along with many, many other factors. Mm-hmm. But as a general rule, the older a child is, the more we're going to consider that, but it is but one of many factors.
Yeah, and it can get interesting, in the case of, for example, you have a child who's perhaps 10 and his or her siblings are, 14 or 15 on up, and they're no longer as interested in coming over to the other parent's home. And the 10-year-old wants to follow suit with the teenagers, but they're not able to have the voice. And so they're still in the position where they have to go, even if their siblings are no longer going. So sometimes we see those kinds of tense situations that can be difficult.
Well, I had a case like that recently, and that's an area where the evaluator's assistance is very helpful to the court.
Yeah.
And especially looking for factors that might be influencing the child's statements as to whether they want to visit or who they prefer to live with. Mm-hmm. And of course, looking to see if there's some coaching going on, which unfortunately happens by parents or others.
Right.
So yeah, we really rely on our evaluators or children's representatives, which are attorneys that represent the kids, for that type of input.
Yeah, and you think you'd like to get to the truth, but what is the truth is sometimes not easy to define. Right. Okay. The other area that I would spend a lot of time examining was school performance and any kinds of issues around special needs. So I might talk with teachers or principals. We definitely would look at their records in terms of grades. I always would ask the children about their friendships and outside, activities and how much that might mean to them. The other thing is if you have a child who's on an IEP or does have special needs, and if there is a concern about one parent living in one school district, another parent living in another school district, and the ability to transport that child so that they can remain in the school that provides the best services for them, those kind of issues can come up, and even in the case of a child being gifted.
Yeah, I would just add that the IEPs are great help to the courts, because obviously you've got treaters' input into those, and it gives us a lot of insight in a very concise form.
Yeah, and I should say too that sometimes in families where there's a lot of conflict, a child could be on an IEP and you would think a parent would know all the details of that child's IEP, but sometimes they don't, and sometimes they can't tell you why the child was granted an IEP or what the concerns are. And just for clarification for students who don't have an education background, we're talking about individualized education plans for children. Okay, so when you have an evaluator who comes into court to testify, you swear them in as an expert witness, correct?
Correct. There's generally a pre-qualification process as to whether that so-called expert is an expert from the legal standpoint. Frequently, the attorneys will just stipulate. However, if the expert is appointed by the court, then they are an expert because we've deemed them such. If there's a dispute as to whether somebody's an expert, we conduct what's called a FRI hearing. FRI was a particular case where it was disputed whether the person was an expert or not. But the general rule is if the proposed expert has specialized training and knowledge in a particular area, and that their testimony may help the finder of fact, which jury in some cases, and in other cases it's the judge, and generally they're going to be allowed to testify.
Yeah, and you know, I wasn't called to testify all that often because most of the time as evaluators, we worked really hard to make sure that wouldn't happen and put that burden on the court's time to call us in. You know, people always have the right to contest the findings of an evaluation and, you know, request a hearing. Doesn't mean, I suppose, that it's always granted, but even when I was court appointed, part of the process would be when you'd go on the stand, they would ask you to tell about your background and training. Right. You know, and so you do have to be prepared to talk about that a little bit. And
of course, generally we have their report ahead of time, so
yes,
we've read it and we know that they're qualified. But nevertheless, testimony can be very helpful in a family law proceeding. The judge is both the finder of fact and the finder of law. So in other words, there's no jury. So when you're testifying, the judge may have very specific questions that they ask the expert. I do that regularly. The longer I've been doing this, the more comfortable I'm at asking questions, because ultimately I have to decide what's best for this child.
Yeah, so you need more information to do that. One of the assignments I have my students do, because we're in a format in our courses where the courses only last 8 weeks, so I can't take them through the entire process of writing an evaluation report, but they'll be required to write a recommendations page. And, you know, I want them to understand that for a judge like yourself, that page is critical because it lists out the recommendations in specific terms in regards to the parenting plan and services and what needs would best fit the interest of the child.
Right. And I can tell you that when the report comes out, that's the page that the lawyers go to right away.
Right.
Frankly, a lot of judges read the recommendations first and then they read the whole report.
Yeah.
But yes, it's invaluable to the court.
Okay, and so I listed here some types of expert witnesses that you might call. Does this, you know, pretty much hold true for the type of folks that you would see in your court, or are there others?
That's pretty much it. You know, we can have medical tests done either by order of court or upon motion by a party. That occurs when somebody has put their mental state at issue. So automatically, if you're seeking custody, it is at issue. Of course, we want to know about any addiction issues, any criminal background, and so on.
Yeah.
So yeah, all of these individuals that are listed up on the PowerPoint are people that frequently testify before us.
Mm-hmm. And I'm thinking too, in the event of there being a history of sexual abuse, there are a separate type of evaluator who conducts that service,
Right.
and might, provide a different kind of report than the evaluator does, which we are, as evaluators may or may not have the information, so they're an important individual who's sworn in as an expert witness as well.
That brings to mind a recommendation that I would have to make reference to any of your background information that you think is relevant. So when we see the report, it alerts us that there are such other reports, or that this individual has information, and so on.
Yeah.
Very helpful to the court, because I may have an attorney for the child, and then when I read the report, I might direct that attorney to investigate certain things that you may not be able to as an evaluator.
Yeah, that's good. So we talked some, whoops, sorry, I'll go back onto that previous slide a little bit. About some of the other types of interviews that we might conduct. Observation, I tended to get the observations in my office because we didn't get the opportunity to go out to the schools or to home, but we would review any kind of testing. And maybe you could talk a little bit about why treaters are not called as witnesses.
Well, under Illinois law, there's a confidentiality to it. And I believe it's commonly referred to as safe harbor. The purpose is to protect the professional relationship, the confidentiality, especially with people dealing with mental health issues or minor children. The concern is that they will not be forthcoming, and they won't get the kind of treatment they need if that information is going to be disseminated, to some third party, whether it's the courts or otherwise. So that's the public policy behind the Illinois law, and it's pretty strictly enforced.
Yeah, and I think even if there are places where that's not the law, ethically, that's what we tend to follow, to protect confidentiality and the rights. We've talked about most of this, but I did mention earlier the CLETS. There's also the National Law Enforcement Telecommunications System, where you access records on criminal activities and any kind of history there, which is extremely beneficial. If I didn't have access to that when I was doing an evaluation that was done privately, because I wasn't court appointed, it tended to make me a little bit nervous not to have that information. So I would dig deeper in terms of police records and try and get the information some other way, because that's invaluable as an evaluator to know if there's any kind of potential for violence or aggression.
There's also another data system that your students should be aware of, and I believe it's a nationwide system called LEADS, L-E-A-D-S, in which domestic violence orders are recorded, and I believe that that's available, from state to state. So that's a great source to get information as well, and certainly something that the courts need to be aware of. If they're, for instance, I may be hearing an emergency here in Illinois because the child is here with one of the parents, but I want to know if there's an order of protection in another state that affects that child.
Right.
And I've had a number of cases where that is the case. I had a mother get an order in Ohio against her. And then she shows up in our court here in Illinois seeking an order giving her the children. So when you're presented with these emergencies, we don't have a lot of information, and the more that we can have in front of us, the better.
Right, and maybe in a minute we'll talk about move-aways, because that happens quite commonly, and I know there's other terms for that as well. But before we move on to that, I just wanted to emphasize that nowadays, email, phone records, social media files, all of those are fair game in the courts and are documents that you would consider as evidence, correct?
That's correct. It's generally called e-evidence, electronic evidence, and it's much like any other conversation that individuals might have in terms of getting that information into evidence in a court.
Mm-hmm.
But of course, we see it all the time now, particularly as it relates to domestic violence situations, also communication naturally between parents and so on. So
yeah, it used to be when I was doing these evaluations, maybe, I don't know, 8 years ago, 10 years ago, you know, sometimes people didn't expect that those things would be admitted into court records, and they would get very loose-tongued, and things that they might say to ex-partners and threatens, you know, statements and that type of thing could, you know, definitely be used in our reports, and I would include them in my evaluations.
let me alert your students again to another source of this type of information. We use both of these in Illinois, and I know they're in other states. One is called Talking Parents, and the other is called Our Family Wizard. At least those are the most familiar to me. And sometimes the courts order the parents to communicate only through those systems. And obviously everything is documented, and we know when it was transmitted and who said what and so on and so forth. So that type of thing might be very valuable to an evaluator, but you might need a court order to get those.
In order to do that. You know, which reminds me too, sometimes I would recommend that families do their exchange at a police station, you know, in really high conflict cases, or a public place, you know, such as a McDonald's or someplace where they'd be less likely to have actions occur.
That's unfortunately in a metropolitan area, that's somewhat common. The more I've done, or the longer I've done this, I've come to the view that the courts should not be imposing that type of a situation on private entities, such as McDonald's or whatever.
Right.
And I'll order it at a police station usually, and I'll give the parents a little talking to and say, if you don't think your child is aware of this, you're fooling yourself.
Right.
But unfortunately, if we have them do it at a McDonald's or Starbucks or whatever, you know, we're imposing, I think, on those businesses almost in a policing capacity, which is certainly not their duty.
Their responsibility, right. And so we would tend to, even if I talked to a friend or a family member, it was not given much weight in my evaluation because of bias.
Sure.
And families would often expect that that would be included and have a lot more weight than it did.
Yeah, I wouldn't suggest leaving that out, but of course the courts are aware of bias. But sometimes there's very valuable information that can be gleaned from what family or friends say. So
yeah, that's true. And especially if there was an event that escalated to domestic violence and that person was an observer, you know, so in that case you would want their information.
Absolutely.
Yeah, so we talked a little bit here a minute ago about relocation cases, you know, and that's, I think in some ways a heavy burden, not only on the evaluator, but on the courts to make that kind of determination, because it changes access for the child in terms of how often they get to see that other parent. You know, but if it were that it provided an opportunity for improvement of that child's life because finances were going to be better or a job was going to be available that wouldn't otherwise, provide that kind of support, then we might make that recommendation. But
these are cases that we see frequently, of course. Again, in Illinois, the standard under which we review a petition for relocation is the best interest of the children. The greater the geographical separation, the more difficult these are, because
yes,
they're certainly cognizant of the impact on the parenting schedule. And most people don't have the resources to be flying children back and forth frequently. And even if they did, we have to consider the impact on the children and so on. So yeah, these are tough cases. Again, an evaluator's input is very helpful to the courts.
Yeah, and I think, as the economy started to tank back in 2008, I got more of these relocation cases. And, I think in terms of the airlines, if a child is under age 7, they can't be put on a plane by themselves. But for me, even looking at a 7-year-old being put on a plane, even though they were going to be, kind of watched over, it still was burdensome to think that that child could be in that situation. Yeah. But, there are all of these different types of cases in which that might, become a necessity.
Yeah, there are many factors that a court will consider in granting this or not. In Illinois, the long time leading case on this is called Eckert, E-C-K-E-R-T, and it articulated certain factors that the court should consider, most of which are now codified in our statute. But I'm sure that these are similar factors that the courts on the West Coast and all over the country, frankly, would consider.
Yeah, and I think you mentioned to me the Uniform Child Custody Jurisdiction Act.
Yes.
And what is that?
Well, it's based on a model that the various sister states subscribe to, kind of a uniform law, although it may vary a bit state to state. But most of the states subscribe to the Uniform Child Custody Jurisdiction Act. And it's particularly relevant in this area. I had a case recently where the mother had left the Chicago area and went down to Texas with the children and stayed with her parents. And she filed actually for an emergency order of protection in Texas. Mm. And then once father was aware of where they were, he filed up here. So under the Uniform Child Custody Jurisdiction Act, myself and the judge in Texas had a conference where we discussed the various states' connections to the family and which state had the most connections and should have jurisdiction over the total proceedings. So that varies depending on the facts of the case, but there is something in the act that designates what's known as the home state, and that's the state in which the child has resided for the last 6 months. So when you're doing an evaluation, you want to ask questions about where they have lived and so on and so forth. Try to get that information before one of the parties becomes aware of the significance of that, because they're going to be forthright if they don't understand what it means. Once they find out about home state, they're going to tell you what they want.
So that'll sway in the direction that they want. Yeah, I remember I was doing a case when I was living in Illinois. The family was in Chicago that I was seeing, and the father lived in Indiana. And so I was called to Indiana to come testify about the custody, So, yeah, it's an interesting process, that's for sure. Okay, so sometimes we recommend supervised visits in the case of risk, and the research will show that in the case of children and not getting to see their fathers, that children do better when they have contact with their fathers, both educationally and developmentally. You know, and I'm just mentioning that because sometimes it's been that these supervised visits, you know, would fall on, you know, these decisions where which parent is going to be supervised and what's the situation, right?
Right.
Yeah,
Well,
and
before we can restrict visitation, we have to have a hearing and make certain findings. So if we were to consider supervising, we would have to find that there's some type of serious endangerment. I think that unfortunately what happens often is what is a temporary situation then kind of becomes permanent.
right.
So, you know, I may have a hearing and find that so-and-so's visitation should be supervised, and then we ask who might be willing and able to supervise it. And a well-meaning sibling or aunt or uncle says, oh, well, I'll do it. Frequently, they don't know what they're getting into.
Yeah, or for how long they're getting into it.
Right.
And you know, before I was mentioning fathers because there was a time in the courts where it swayed more in the direction of mothers, even if mothers weren't the best fit. You know, and fortunately, I think, you know, we've seen changes in that. There's groups that protect fathers' rights and are more interested in making sure that children do get time equally when it's not a risk situation.
Well, certainly our laws here in Illinois are neutral, gender neutral.
Yeah.
And I have to say that the professionals are truly driven by the best interest standards. But what you were referring to used to be known as the tender age doctrine, where there was a presumption that children under a certain age should be with mom. And it was pretty much automatic. Although that's many, many years ago. And obviously the standard now is the best interest of the children.
Which is great. Yeah. Yeah, and so we do have some organizations out here where if there is no one that can be appointed, you can pay for the service. It's sometimes difficult to find services that are affordable for families. There are some agencies connected to Department of Human Services that will provide it. And so, you know, these are just the different options in regards to when we are required to provide supervised visits and what we might decide.
Yeah, we have the similar type structure here in Illinois. Certainly when they're paying someone to supervise, we want somebody that is experienced and capable of addressing situations.
And you know, and I found too that that might be an individual I would interview as part of my evaluation process, because it may be that while they're in mediation, these families might have supervised visitation, because you might get cases where they've already had an evaluation and they're coming back to the courts for a higher level of evaluation or a second evaluation. And I've done those cases as well. So I want to talk a little bit about children's rights. You know, we've already spoke to age factors. You talked a little bit about parental influence, and you know, we sometimes look at parental alienation. People argue as to whether or not that really occurs. I think you and I are both of the mindset that it does, that people do coach children and influence them and sway their thinking. Legally, I think out here anyways, we can't leave children alone before the age of 12 or reason, depending on their ability to be independent or mature enough to be able to know how to handle an emergency situation. You know, and these kinds of situations currently with electronic parenting and helicopter parenting, those come into be addressed in my evaluations, and I'm sure they get talked about in the courts as well.
Yeah, Claire, you broke up a little there. Yeah, I'm curious as to these new devices that allow you to monitor everybody's comings and goings from your home.
Mm.
And how that might affect court's consideration of the latchkey kid situation.
Right.
Uh,
Yep.
Everything is case by case basis, of course, before the courts. So.
Great way to say that. Yeah, so I mentioned sometimes we do reevaluations if new issues arise that put the best interest in question, or safety issues, concerns about disciplinary methods, if there's a change in status, mental health. Parents can bring concerns about the other parent, to the courts. If the child is of age where they can start to speak about their wishes. And I think you mentioned to me one time anyway about non-custodial parents seeking child support.
Yeah, I had a case involving exactly that. And in Illinois, there's precedental authority to grant that. Probably the easiest example of that would be somebody earning a minimum wage, divorced from an individual who has, a substantial income. That even though the wealthier parent might have custody, the other parent could seek some support so that during the time that the children are with them, they're able to provide a certain level of comfort and activity for the children. That's the classic case here in Illinois, a situation like that.
And I do think you have a lot of cases where there is that disparity. And sometimes as evaluators, we might make recommendations if the parent with the more wealthy means has more time with the child in order to balance things out. If they had the revenue to support visitation, especially if it was involving a relocation situation, where maybe the financial responsibility might be on the person who had more funds, so that the child would still get, time with the other parent.
Right.
Yeah. So we also want to look at the future of the child. We tend to keep these records until the child is age 18. But there are, again, all these different factors to consider because things aren't stagnant. The needs of the children and what determines the best interest changes over time. So we have to consider risk and maybe conduct risk assessments. There's all these other things that, really probably are more than we want to talk about here and now, but they add to the complexity of these cases. You mentioned even something very benign as like pet ownership can come up in these cases and become a point of argument.
We actually now have a statute that allows us to allocate time between the owners of the pet.
Yeah.
We all know that people become attached to their pets, and lots of them consider them family members. So it is something that we have to consider.
Yeah, and I think that just emphasizes, how intense these cases get. And there's complex issues like children that were adopted, or issues of foster care, and reunification cases, with parental rights are another whole area of expertise and concern. So, all right. I know we're running short on time here. So I think, as you've emphasized here, our main focus is the best interest of the child. So we look at, clearly defining the reason for the evaluation and the focus of the evaluation. It's important to get that written out and defined legally so that the terms of the evaluation are clearly stated and understood for the parents as well.
Yeah, I would encourage evaluators to seek direction from the court in terms of the scope of the appointment if you're not certain.
Yeah.
As a judge, I welcome that. You're in a good position to tell us what you need us to give you to assist you, of course.
Yeah, and I think also from the point of view of ethics, it protects us as evaluators to know specifically the scope, so that we're not stepping into areas that we're not assigned to evaluate.
Yes.
And it protects you from complaints, because if you start talking about things in the report that really were not part of that scope, you can anger some parents, rightfully so, and they can file complaints with the board against you. So you want to avoid getting into that kind of situation as much as possible. So mostly we work towards workable solutions that protect that best interest and protect the children and any kind of further victimization if that's occurred. Offering crisis intervention suggestions and recommendations. We want to be very sensitive to any trauma history there and focus on developing and supporting healthy relationships. I just mentioned this organization because it's worth looking into. If you're going to do evaluations, you want to know about the Association of Family and Conciliation Courts and perhaps join and become a member of that. They provide wonderful education and workshops and seminars. So that would be, I think, something to pursue.
Great resource.
Yeah, well, thank you very much for joining us, and I appreciate your time. And I really am glad you were able to speak with us today.
I appreciate the opportunity, and now I'm sure that your students know everything they need to know.
And then some.
Thanks, Dr. Steffen.
Okay, take care. Bye-bye now.
All righty. Are we still on?
We are. I'm just